Good morning and welcome to the Justice Committee's second meeting of 2020. We have no apologies, but Liam MacArthur may be late. Agenda item number 1 is consideration of the Children's Scotland Bill. I refer members to paper 1, which is note by the clerk, and papers 2 and 3, which are private papers. We've 2 evidence sessions this morning, and I welcome our witnesses for our first panel. June Loudon, Grandparents Apart. Ian Maxwell, National Manager, Shared Parenting Scotland, and Dr. Sue Whitcomb, Chartered Psychologist. Can I thank the witnesses for your written submissions? As always, these are really, really valuable to the committee in advance of hearing from you in person. We'll move straight to questions now, starting with Jenny Gilruth.
Thank you, Convener, and good morning to the panel. I'd like to start with a couple of questions around about children's participation in decisions that are made about them. And a note from your written contribution, Ian Maxwell, from Shared Parenting Scotland, you state that children are likely to feel they are under pressure. Sometimes parents and other family members may attempt to influence the child during the time views are being obtained in terms of that decision-making process. And I think this is also highlighted, Dr. Whitcomb, in your evidence too. I wonder if you could say a wee bit more on why that challenge exists and also what you think might be done to overcome it.
Children who are in the middle of a parental conflict have got divided loyalties. Usually they'll have loyalty to both parents, and when they're stuck in this position of being between conflicted parents, they are finding things difficult. Sometimes they'll say different things to each parent because they want to say what they think the parent wants to hear. And that's why it is really important that if you are taking children's views, you take them in a way that is separate from their parents' influence, allow them a bit of time. Also, if somebody strange is taking evidence from a child, the child needs to build up confidence and know that that person is really on their side. So, for instance, Avenue, the service in Aberdeen that does mediation and child contact, they say they want to see the child 3 times, because the first time the child will tell you what they think you want to hear, possibly what they've been told to tell you. The second time they'll relax a bit, and the third time you might actually get closer to the real feelings of a child. The other aspect I would mention here is that when children often will say something very negative about the parent that they are not seeing, and yet that needs to be taken carefully. The work that Dr. Kirk Weir did a number of years ago, he was instructed in a number of court cases, a large number of court cases in England, once they have established that there wasn't domestic abuse in the case, to go and speak to the children who had completely rejected one parent. And that was rejecting both mothers and fathers. And he found that either in a few minutes or maybe over the course of a meeting or two, he could, in a lot of the cases he dealt with, the child who had previously been completely rejecting of a parent would unwind, and in many of the cases he dealt with, not all of them, the child was happy to meet with the parent and was enjoying the meeting with the parent. So this is where children's views are incredibly important, but they've also got to be taken very carefully in this situation.
Yeah, I'd like to say that everybody is influenced by the people around them to form their views and opinions, adults as well as children. And it isn't just in relation to parental separation. We're well versed now in the issues of child sexual exploitation and grooming and religious radicalisation, and all of that involves influence to a certain degree of people, adults and peer groups around children and young people. I think what Ian is saying is quite right. Often I will hear a child express very different views when they are in the presence of one parent to what they say when they're in the presence of another parent. And there is often a situation where a child might be vehemently saying they do not want to see a parent, that they hate that parent and they never ever want to see them again. Yet within 10 or 15 minutes of being in that parent's company, they are very much enjoying their time with that parent, they're playing with that parent, and they're very comfortable with them. We need to understand what is going on for the child, and not just what a child is actually saying, but where those views come from, and when those views differ from what their body language might be, or why they're saying that in light of the entirety of their experience with those parents. So quite often you will see children who are not necessarily overtly coached by a parent to say that they don't like the other parent, but they pick up on what their parents' feelings are. Children from a very, very young age are attuned to their parents' feelings and how that parent feels. So a child learns from a very young age that A, it might not be acceptable to talk about the other parent because mum or dad gets angry or gets very upset. They tune into their body language. At handover, if a parent is anxious or a parent is giving messages that aren't overt to the child will pick up on those messages, and their behaviour will change and their expressed views will change. In England and Wales, there is the work of Cafcass and Cafcass Cymru. They look at the ascertainable wishes and feelings of a child, not just the expressed wishes of a child. So we need to understand that for all children and all adults, sometimes we say things that we don't actually mean, and there are reasons behind that. So if a child is expressing quite strongly that they do not want to see a parent, my first point of call is why? Why does that child not want to see a parent? Because that is a very unusual behaviour. It is normally a sign of psychological distress, and we need to understand why that child is saying that.
Do you want to come in, June Lydon?
I agree with both these points, and I have personal experience within my family of exactly what Sue has been describing there.
Okay. In terms of taking evidence from very young children, NSPCC Scotland have said that it thinks that very young children can offer a view provided that the appropriate infrastructure is in place for them to do so. I wonder if the panel could say a wee bit more about taking evidence from very young children and how that might differ from other children.
For me, when I'm working with very young children, obviously we do not ask direct questions at all. We sort of investigate. I mean, we do a lot of play work, we will work through games, we will work through creative means to try and understand that child's worldview and that child's experience. We would do a lot of observation of that child as well. So we're not just looking for what a child says verbally or what they produce in creative work, but we're looking at their body language around when they are with a particular carer or a particular person to try and understand what might be going on for them too. Mm-hmm. I absolutely agree with some of the previous evidence sessions of Chloe Riddle and Joanna Barrett and Dr Whitecross, saying that there is a need for skilled professionals and a different skill set and knowledge to that which current solicitors who are child welfare reporters have. I would also say that there's a different professional framework around that as well, that as professionals who work with children on a regular basis, who our training is involved around child development and understanding a child's process, we have a different professional framework in that we have clinical supervision. So if we're unsure about something or we want to check something out, or even if we have an implicit bias that we're not aware of, that is sort of thrashed out in professional supervision, and that is something that child welfare reporters who are solicitor trained don't necessarily have. Mm-hmm.
We have already in Scotland joint investigative interviews conducted between police and social work where there are allegations of child sexual abuse or other serious things. And while that's maybe not quite the format for some of the talking to children, there are lessons from that in terms of how you frame questions, how you avoid leading a child into particular things. There's a lot of experience already in that field, and I think the people who are doing the work with children, particularly in the more difficult, the sensitive cases, they do need to have that training. And that's why when we had the Bar Reporters Working Group several years ago in Scotland, one of the key recommendations from that was training for the people who are doing this work. That was scuppered by the judiciary not being keen on having it imposed on the system, but we welcome the fact that there's mention of training and supervision of child welfare reporters in this bill. We don't actually agree that they're necessarily the best people to do it. We feel that professionals who've got a slightly wider skill set, or lawyers who've trained up and who've got sufficient experience could be doing it. But it's a difficult job and it requires a lot of understanding. And as you say, dealing with very young children, they do need to give their views, and knowing how to do that is not an easy job.
I think sometimes just the adversarial nature of the legal system creates a larger animosity between couples when they separate, and the parent who has the main carer for the children can inflict their opinions, their fears, their anger, even just in the room talking to other people when the children are there, and as have already been said, they pick up on that and they form their opinions based on that. And even if the legal system wasn't so adversarial and better negotiation techniques were used, finding out what's happening rather than it being a competition, I think it would go a long way to minimise that. It wouldn't prevent it in every case, but it would certainly minimise it.
Thank you.
Rona, supplementary, and then John.
Thank you, Convener. Good morning, panel. I wanted to go back to my colleague's first question, if I may, and just to draw your attention to a letter that the committee received from a large number of academics and children's organisations and women's organisations. And it's with regard to parent alienation, which they're very concerned that would be on the face of the bill. And they suggest that it has the potential to divert the focus from children's welfare as the paramount consideration in contested child contact cases, and to disregard children's views and associated participation rights. And they also say that the research done in England said that parents who were implacably hostile, i.e. parental alienation, was a factor in very few contact cases. Could I ask that, what's your view on the point that, you know, the approach that you've taken and in your submissions could cast doubt on domestic abuse allegations?
Well, just to give the committee some context about the letter that was submitted yesterday. Subsequent to that, the Medical and Scientific Committee of the World Health Organization, who are the people who are doing the international classification of diseases, they took that into account alongside a lot of other submissions, both pro and against parental alienation being included. They have concluded that parental alienation is a type of caregiver/parent-child relationship problem between children and either caregivers or parents, and it is primarily relevant in forensic settings. It is not a disease or disorder and is therefore located in Chapter 24 of ICD, which is about factors influencing health status or contact with health services. Now, I can give the committee the full details of what this conclusion was. It is a controversial point. But the Bar Reporters Working Group that I referred to earlier, that I was on and Scottish Women's Aid were on, did agree that parental alienation should be amongst the topics that is on the training list for anyone who's working with children in this area. And I would refute the suggestion that it's going to divert from allegations of domestic abuse. I think both are serious issues and both need to be taken seriously when we're dealing with children in this situation. Also to say that parental alienation is a very severe form of influence, and there are now diagnostic characters. I'm sure Sue can tell you a lot more about that. We tell the people who come to us, don't assume that you've got parental alienation just because your child was a bit unhappy when they saw you last. There are very ill. Don't diagnose it yourself. Talk to the experts. But I think Sue can tell you a lot more about that.
I think my concern is, as a practitioner who works in the field, that there is a lack of awareness and understanding of what might be alienating behaviours on the part of an adult who does not want a child to see another parent. We are well versed in domestic abuse and domestic violence. There's been a massive increase in our knowledge and understanding and the provisions that are put in place to cope with domestic violence. The definition of parental alienation is the unwarranted rejection of a parent, of a good enough parent, where there is an absence of abuse, where there's an absence of harm to that child from that parent. So we are looking at situations where there is a good enough parent, there is a history of that parent having a good enough loving relationship with their child, and there is no evidence of abuse or harm to the child from that parent. In a case where a child is rejecting such a good enough parent, we need to understand why, in the absence of domestic abuse or harm. In reality, cases can be very, very complex. So in the report prepared by CAFCAS and Women's Aid Organisation, they looked at, I think it was 66, a number of cases around allegations of domestic abuse in family court. And they found about 62% of those cases in the family court had allegations of domestic violence and abuse. And I know your previous witnesses have talked about maybe about 50% of cases having allegations of domestic abuse when they come to the family court. We do not know how many verifiable cases of domestic abuse or violence there are. We have to accept that not all of those allegations will be founded in the final state of affairs. Some people do lie, some people do manipulate a system, some people are manipulative, and that applies to people who come into court where they claim domestic violence and where that might not be the case. Some people do that intentionally, but also some people do that because of their psychological functioning, if you like, that they may have a perception that they have been in an abusive relationship, but it's not accord with objective reality. If I can give an example, this has been playing on my mind. I flew up here yesterday in the wake of Storm, was it Brendan? I'm not sure what it was. It was a slightly bumpy flight, and my anxiety was slightly higher than it would normally be. If you checked in on the anxiety of everybody on that plane, we would have all have rated their anxiety quite different. But we're all experiencing the same flight. But our perception of what that does to us is very different. And sometimes that happens in relationships with other people too. So some people are naturally cautious about relationships with other people, find every relationship that they have, every interaction they have with other people to be quite belligerent, that people are picking on them. And sometimes that goes into then allegations of domestic abuse and violence too. So many of the cases that come before the court are quite complex. In that report done by CAFCAS and Women's Aid, there were more than one factor in the majority of those cases. So domestic violence allegations were in there were allegations of substance misuse, there were allegations of parental mental ill health. I think more and more we are seeing more complex cases come before the court. And to say that this is domestic violence or it's not domestic violence, this is parental alienation or it's not parental alienation, is not helpful. We need to understand the worldview of that child from the situation that they're in, with many complicated factors around them. And in order to do that, we need to understand that some parents may be manipulative, some parents may be overprotective towards their child, and that some parents are domestically abusive. But we need to have a full picture of what's going on for that child.
If I could just add, on the question of domestic abuse, the assessment that was made in the paperwork was that 50% of the family court cases in Scotland involve allegations of domestic abuse. However you'd work out how many allegations are substantial, that still leaves a large number of worthy parents who are coming to the court in order to see their children. And this bill is about those parents as well as the people who are trying to deal with the impact of domestic abuse. And I think it's really important that this bill acknowledges this.
Excuse me, Mr Maxwell, can I stop you there?
Sure.
I was under the impression this bill was about children, not parents. It's about children.
It's very important for a child to see a worthwhile parent. That's why I agree. The bill is about, it's the Children's Bill, it will be the Children's Act, but the child who is prevented from seeing a worthy parent is just as vulnerable as the child who is just as important as the child who's protected. Lady Hale, the just retired Supreme Court head, made that comment in one of her judgments. It is just as important for a child to know that they have not been abused if they haven't been abused as it is for the child to know that they have been abused. Sorry, I haven't got the quote right. It's in my submission. But Lady Hale made that point. And I think we're not just, if the process is concerned with this bill were just about protecting children from domestic abuse, it would be a different bill. It's not. It has to do of the judges and sheriffs who are in these courts have got to do a very complicated job trying to unravel these factors. One judge recently described it as one of the most difficult jobs that the judiciary has to do now that capital punishment is no longer there, because they're having to make very important decisions about the long-term position of children in relation to their parents.
Thank you. Ms Loudon.
I just find it very difficult to understand why a lot of the arguments are focused around female victims mainly of domestic abuse, because there are many, many male victims of domestic abuse, and they seem to have been forgotten in all of this. And my fear for the children in this respect, on TV in particular, you see loads of promotion and awareness highlighting the issue of domestic abuse, and it's always a female victim. So children seeing that advert in their own homes, okay, my mother's being abused, it's a difficult situation, I understand that, it's in their head. If your father is being abused by your mother, there's nothing on the television to say that's usual behaviour or accepted behaviour. So what do those children do? Where do they go for support? I noticed in the submission from Women's Aid that they have support things in place to help children of abused mothers. There's nothing for that for abused children.
Can I disagree with you, please? I mean, the children's organisations are there for the children.
Yeah.
It doesn't matter whether they've been abused by, abuse is wrong at all levels,
Absolutely.
whether they've been abused by a father or a mother, but the
Yeah.
children's organisations don't discriminate on that.
Women's Aid have their own particular support system for children. There's no male abuse support group has been consulted in this bill at all, and they are fathers of children as well, children who are affected by that. You have the male thing. There's not as much support system. There's not as good a support system out there for them. There's not as much promotion that it happens. The courts find it difficult to deal with it. The police find it difficult to deal with it. There's an awful lot of assumptions made when these things happen in day-to-day life, that the female is the victim. There was an article in the paper in November, and Erin Pitsey, the older people here will remember her. She set up the original Women's Refuge. And in this article, I can show you a copy, I've got it here. She said of the first 100 women who came to her refuge, 62 of them were more violent than the men they were escaping. So it's not as simple as domestic abuse. There are a whole range of situations within family separations, family fallouts, death of a parent. And this seems to be focusing on the Women's Aid and the abuse part of it instead of encompassing the whole lot and how children are affected by it.
I'm quite, speechless, to be perfectly honest with you. I mean, I think to say that domestic abuse is just part of it, surely that's paramount. If a child's been domestically abused, that's what matters.
That's absolutely
and it
right.
shouldn't.
It's
so I've not
absolutely
really heard a response from you to say whether you think this would cast doubt. Your approach would cast doubt, which is disputed.
I don't think it casts doubt
your
at
evidence
all.
is disputed by so many women's organisations and academics, and they deal with this every single day.
If you cast your mind back to 60s and 70s when domestic abuse wasn't so out in the open, there wasn't so much support there for women. We're there now. with men. We are there now with men. Men are still frightened to speak out. There's just the shame of the fact that they've been abused by a woman, the lack of support systems. It's not just a one-size-fits-all, and we need to get this right for every child, whether they've been in an abuse system, an abuse situation or not.
I suppose really what you're really trying to get over, if I understand you properly, is to highlight the fact that there are many cases where domestic abuse isn't a factor in the first instance, and we shouldn't overlook that.
Those children.
And that secondly, obviously not all cases of domestic abuse in all cases, then it isn't, although the majority tends to be, then not all the perpetrators are males sometimes.
Yeah, not all cases go to court.
Okay.
Alienation happens when it's not a court situation.
Yeah, okay. Thank you. Ronan, anything else? John and Fulton, supplementaries.
Yeah, thank you, Convener. Good morning, panel, and thanks very much for your contributions. As ever, they're very helpful. And clearly, it's a very emotive subject, and there are strong views on either side. The committee has taken evidence in the domestic abuse bill from a range of people, including victims regardless of their gender, and we've looked at the issue of elder abuse, so I assure you the committee takes all aspects of abuse very serious. Dr Whitcomb, can I ask you something? Because we want clarity about, there's been a lot of references to, excuse me, academic research. And you state in your written submission here, if I can quote please, it is evident in court paperwork that there is often a preference for the subjective narrative of one parent. In particular, assumptions are regularly made that the parent who is currently in care is in care of the child, I beg your pardon, is the better parent and likely to be truthful. Can you direct can you direct the committee to the academic research that would support that statement, please?
I couldn't off the top of my head, but I will send you information for that if I can find
Thank
that.
you.
That is obviously about my professional practice and what we see in professional practice, that there is sometimes an implicit bias for people who are working with families, and more time is given to the parent who is seen to have care of that child at a particular moment in time, and more weight is sometimes given to their views than for the parent who is not seeing the child at that moment in time.
I wonder, would you acknowledge that for a great number, and invariably, statistically, it's more likely to be women, that that's not their experience of the civil courts?
I can only speak from the cases that I work on, obviously. And I acknowledge that the tens of cases that I tend to be called in to work on are those at one extreme end of the scale.
Okay, thank you very much.
Fulton? Oh, sorry, Mr. Maxwell.
I can point the committee to one bit of research I know of, which was dealing with the way that social work was relating to the parent who is caring for the children and the parent who is not. And certainly I'll send the reference to the committee, because that was definitely showing that social work was less interested in taking up or supporting the other parent, particularly the male other parent. So I think there is a reasonable amount of evidence of this.
Do you have anything to add, Ms. Loudon? No. Okay.
Thanks, Convener. Good morning, panel. Just as a brief declaration of interest, welcome Ian Maxwell, who chairs doesn't chair as the Secretariat on the shared parenting cross-party group that I chair. So a quick declaration here. I wanted to stay on this issue because I do believe it's the crux of the matter around this bill, around domestic abuse and potential alienation, which I think that everybody around the table and MD watching would agree that both are wrong, and we would want to stop either from happening. But I think that the difficulty is in it as a committee that's just looked at the new domestic violence legislation which is passed. It's how do we prove, because we've talked a lot about those 50% cases aren't domestic violence. I find it difficult to understand how we would prove that as the case, because they may be undisclosed domestic violence, particularly around perhaps emotional abuse if the physical aspect isn't there. So I am slightly uncomfortable with that. However, at the same time, I am aware that alienation is a major issue as well. So I wanted just to go back again to ask, how exactly do we try and make that right, make that dilemma right? How do we get to the bottom of that? And I think just now what agencies, services and politicians are probably doing, certainly I would say that I would fit in this category, is implementing the precautionary principle. Because until we find a suitable solution to that, I would rather that we avoid children being exposed to domestic violence, and I'm sure most people agree with that. So would you agree that the precautionary principle is being implemented, and how can we bridge this gap?
Can I come in there?
Yeah.
We need to be aware that working on that precautionary principle, that we will be leaving children with parents who are harming them and are abusing them. Because in some cases, the level of abuse and the level of harm experienced by children who are alienated is very significant. There are ways of differentiating between domestic abuse and parental alienation. And CAFCAS in England have brought in their child impact assessment framework, and they have started looking at what alienating behaviours are in parents. And we also look at what the symptomatic behaviours are in children. So when you're working with children to try and understand what their experiences are, the vast majority of children are very ambivalent about their relationships with a parent. A child who has been physically, sexually abused by a parent still wants to see that parent. They may feel a little bit frightened, they might be quite cautious, quite anxious, but on the whole, the majority of children are quite ambivalent and still want a relationship with that parent. And we need to protect those children and allow them to have a safe relationship if it is appropriate to do so. It is very different with a child who is alienated, where their thinking is very black and white. They're very strident. They say they hate their parent and they never ever want to see them again. This is in direct contrast to their experience of that parent, where there is much evidence of them having a loving, normal relationship with that parent. And when challenged with that evidence, they come up with very frivolous reasons for not wanting to see a parent. And it's not that that parent has hurt them. It is things like, they forced me to eat broccoli. They made me go to the park. They bribed me with chocolate. These are the reasons children are giving for not wanting to see a parent and appearing very, very anxious about seeing that parent. There's a very much an idealisation and a devaluation of one parent and the other. So typically when we do assessments with children, they will have a range of responses which say they like their mother because of this reason and their father because of this reason. This is what they don't like with their mum and this is what they don't like with their dad. All children have good and bad feelings normally about their parents. In the case of an alienated child, it is very black and white. One parent is the source of all their positive feelings, and they cannot say anything negative about that parent at all. And the other parent is the source of all their negative feelings, and they cannot say anything positive about that parent at all, even when probed. And please bear in mind, we're talking about children here where there is an absence of abuse. Okay, so that is a very unusual response, and that is how we start to look at what might be going on in that child's world. In terms of alienating behaviours on the part of a parent, it is never right to tell a child that the parent doesn't love them. It is never right to stop to tell a child to stop calling their other parent mum or dad. It is never right to suggest a parent is a danger where there is no evidence to suggest there is at all. It is never appropriate to prevent or discourage a child talking about their parent. Okay, so in these families, the child is not allowed to talk about their other parent because the parent they live with becomes angry or distressed. It is not right to stop a child having a photograph of their other parent if they want a photograph of their other parent. And this is what happens in these families. And it is never right to reward a child for not going to have contact with that parent. And these are some of the alienating behaviours that we look for.
So I think that's a very detailed and quite interesting response, and it seems to be based on research and experience. But how is that information? How can it be dispersed into the agencies that would be dealing with these situations? Because as a fairly experienced social worker in children and families for 8 years, I have to say that isn't anything that was any specific training on. Lots of training in other areas, but not specifically on that. So clearly there is that gap there, and I think that most of the agencies in Scotland and the politicians I said earlier would be keen to edge on the side of caution when it comes to domestic abuse, because we know the well-researched and well-documented negative effects that domestic abuse have on children.
The issue is we don't know what we don't know. And if we're faced with a situation and we have no knowledge of what alienation is or alienating behaviours or the symptoms in a child, we will try and fit the child's response into the framework that we have, which might be a framework of abuse and violence, and we don't understand. We're at, I think, with alienation where we were with domestic abuse and violence 20, 30 years ago, in that we have a great lack of understanding and knowledge which needs to be rolled out there. On that, I have to say that I was invited up here last year to deliver training by children in Scotland on parental alienation. And there was a significant lobby by the Women's Aid, Scottish Women's Aid, to prevent me from delivering that training on parental alienation. And I find that quite worrying.
Right, John, thank you.
Thank you, Convener. Yes, panel, back to specifically the bill, if I may, please. Would witnesses like to outline whether they think there should be a list of the different ways that children's views can be given to the court, and the child given a say in the method that's used in any individual case?
There has been a lot more work done on this by CAFCAS in England. There are lots of ways that children could give views, and obviously children are maybe more familiar these days with social media and online things than with pencil and paper. I think it's important that it is open to children to give their evidence. I think the Scottish Courts and Tribunal Service, and possibly one of the other submissions, stated some of the practical problems there might be, and unfortunately our Scottish courts are not nearly as computer savvy as they might be, but they are getting there. The things are changing. But certainly there are a range of ways, and just as when the Civil Justice Council, the Family Law Committee, which I was on, determined how best to revise the Form F9, which was a horrible process. The old Form F9 was a horrible thing with capital letters and unfriendly language. The committee did work with children's organisations to try and find out what would work best with a form. And it took us nearly 3 years to redesign that form. I would hope that we can move a bit faster, because children can't wait. Children do want to give evidence in different ways. And the emphasis in this bill already on both involving children and feeding back to children is, I think, very important. But you will note that it has produced quite a counter-reaction from the legal profession, and particularly the judiciary. I'm afraid the judiciary are very much, I think, almost frightened of having to... partly they're saying they don't want the extra work. They're already overburdened, but I think I've got other answers for that. But they are... They do not like the idea of having to feed back information to children. And yet one of the things that I do support very strongly in this bill is that part of it, because I think it's an important, and it's obviously part of the UN Convention of Children's Rights compliance that we're aiming for.
Other panel members' views on a list, an exhaustive list, or like to cite any innovative ways that children could?
This is unhelpful. I think the fact that the professionals who work with children all the time know how to elicit their views, and I think that might be one of the issues, that we're trying to encourage people who do not understand children very well, or we're trying to encourage a wider range of a specific group, maybe welfare reporters, and maybe be the judge to or the sheriff to hear those views in a way that's very much adult orientated. As people, social workers, psychologists, child mental health professionals, teachers know how to take children's views, and I think to try and restrict that by an artificial list would be unhelpful. I have to say how I just could not believe the F9 when I first saw the F9, the old F9. I haven't seen the new F9, I don't think, but I was just astounded that we were trying to take children's views by that manner, really. I thought it was very unhelpful.
Okay, thank you. Ms. Loudon.
I think a list's only helpful if you don't know what you're looking for. If you've been trained properly and you can, you've been trained to how to work and speak to and communicate with children of various ages, you don't need a list to find out how they feel and what they want. You would include that in some education and training for families as well as professionals.
Okay, thank you very much.
Linker.
Convener, good morning. I'd like to ask about confidentiality. Now, in 2018, the Scottish Government consulted on a provision which said that if a litigant asks for it, then confidential information should be provided, but only if it was in the best interest of the child and if the views of the child had been considered. Now, that's not in the bill, and this committee's had representations that that is a significant omission, and there should be something there, but equally, we've heard the opposing view that this could be prejudicial and a breach of the human rights of the parents. So I throw the question to the panel. What's your view, and should there be such a provision on the face of the bill?
I'm familiar with what I think is the sort of case that's often being referred to in this. Obviously, I can't say anything about the detail of that case, but as I pointed out to one of your panel from last week, in that case, there was a lot of concern that the children's views given to a domestic abuse service had been then revealed through the court. But subsequent to that, there was a proof in that case, and the sheriff in that proof concluded that the children had not been abused, and furthermore sent a letter to the children effectively saying that to them. So this is where the checks and balances, the rights of both the parents and the children need to be dealt with. And if you have an allegation of abuse, you do have to be clear that it is an allegation, and that if you get it wrong, if you tell children that they've been abused when in fact they haven't been, you are doing just as much damage as if you are not reacting to their reports of abuse. And I think the status of the bill at the moment is probably okay, because it does it doesn't make it does allow for that sort of extra stage of checking.
So if I might press you on that, I think Dr. Whittingham's going to come in, but before you do, so when you say the status of the bill is currently okay,
Yes.
you are comfortable that there is no such provision incorporated within the bill?
Yes.
Thank you. Dr. Whittingham.
I think the issue of confidentiality is something that is obviously very close to my work, always. And the issue of disclosing information to the court, which has been given in a therapeutic setting, we are clear when we contract with all of the people that we work with, children and adults, that there is a limit to the confidentiality and the information that they give us. And if we have concerns that that child might be at risk of harm, or that we are required to by the court to disclose that information, that we will have to disclose that information. And that needs to be made explicit to adults and children at the beginning of any therapeutic process, so that they are clear that there are situations in when that confidentiality may need to be broken. Coming back to your point about this being an issue of the rights of the child or the rights of the parent, I see that very differently. I see this very much as a safeguarding issue for children, because sometimes children are taken to a service by one parent for therapeutic input, and it seems to sound like that's the case that Ian is talking about as well, where that service only takes intake information from one parent, and they have one side view of what might be the issue going on for the children. The work that begins with the children is framed around the narrative that one parent has presented to them, and those children may well be being harmed by the therapy that they are receiving. So this then becomes a safeguarding issue. In my work as an expert witness, I will ask for court notes of therapeutic sessions sometimes where I feel it's appropriate to do so, where I feel that there may be inappropriate therapy happening with an adult or a child, or where I feel that this may point to other safeguarding issues. Often in England and Wales, that information is disclosed to me, but not to the litigants. I will include the relevant bits that I feel are relevant within my report, but the whole of the information is not provided to the litigants.
Thank you for that. And so if I might press you with the same question asked Mr. Maxwell. So is it right that this is not on the bill, that this provision that was consulted on, or would you prefer to see it?
I don't think we can ever guarantee confidentiality.
So should it be on the face of the bill or should it not?
I'm not a lawyer. I'm a psychologist.
June Loudon, do you want to?
I don't have enough experience in the confidentiality thing to comment, other than that confidentiality should be broken if it's in the interest of the child. Whether it should be in the bill is a technical thing.
Thank you.
John, supplementary?
Thank you very much, Convener. Mr Maxwell, it's about your organisation's response regarding parental rights and question 10 there. Now, I'm hoping I'm picking this right. Parental rights and responsibilities should be awarded indiscriminately. Particularly the issue of cases of rape or incest, and a reference to an application could be made to the courts to have parental rights of the rapist, abuser withdrawn if deemed to be in the benefit of the child. Can you clarify that? Because these views are abhorrent to many people and would seen as being an attack on fundamental human rights, not least taking a child rights-based approach to legislation.
I think I'm taking a child rights-based approach too. As you got from the evidence, from the information provided by the civil servants, around about 2,000 fathers per year are not included on their child's birth certificate. Amongst that group, there will be some who are not worthy, and we do need to find processes that will quickly and accurately prevent that parent from getting any further involvement with the child.
Worthies are rather, sorry to interrupt,
yeah.
worthies are rather peculiar term.
Okay.
How would, who'd make that assessment and based on what?
Well, it might be a social work assessment or a children's hearing assessment or a court assessment. It really depends on which process things go through. But if we look at other countries, plenty of other countries give parental rights based on genetic linkages rather than on marriage. Less than half of family... In Scotland, we give every child who is born to married parents, sorry, every married parent, the parental rights automatically, but we have more than half of our children born to unmarried parents now.
Could I ask you that you focus, please, Mr. Maxwell, your reply on the issue of rape and incest that you refer to in your response to question 10, please. Okay. Well,
I quite agree that a child who is conceived through rape and incest should not have a parent imposed upon them. But I wonder how many of these 2,000 are the result of rape and incest, and how do we protect those parents whose name is not on the birth certificate, but whose children should still have a knowledge and an involvement with them? And this is a balancing act. Different countries have done different things with this. In England, although the law is similar, law was changed but not implemented to have compulsory registration of both parents on birth certificates. The law was passed but has never been implemented. But as I said, in other countries, both genetic parents are given the parental rights and responsibilities automatically. And if you note the Dr. Barnes-McFarlane's report, which the committee commissioned, raises this as a UNCRC compliance issue, and this is about the right of a child to know of their origin and of their parents. And it was queried when the 2006 Act was...
Mr. Maxwell, sorry to interrupt yet again. I do beg your pardon.
Yes, sure.
I was asking about parental rights, not the rights of our children. I understand, and people may understand, that people would want to know who their biological father is.
Yes.
But granting parental rights to a perpetrator of rape...
No, I mean, please, I am not trying to grant parental rights to rapists. That's very clear. I'm fully in agreement with you. But I am concerned about these non-raping, perfectly worthy parents who are having to go through extraordinary court procedures, extraordinarily complex and sometimes expensive procedures in order to have any sort of impact on their children. And it's obviously that is the child losing out from the potential of having involvement of a perfectly good parent. And obviously there's a gender aspect to this, because every woman who is automatically given parental responsibilities and rights, but only the unmarried fathers whose name is on the birth certificate are given the parental responsibilities and rights. And I think this is something we come across this a lot, of fathers who are finding it very difficult to progress their contact and involvement with their children because of this. So you need the protection. You need the protection of rape and incest, but you also need the protection for the children of the fathers who are losing out at the moment.
Thank you. Thank you for that. Fulton.
Thanks, Convener. I was wanting to ask just a wee bit about some of the terms that are used in the bill, what your thoughts on those are, and if you think there's any practice implications, and particularly in relation to the use of the terms residence order and contact order. I'm aware that other countries, including England and Wales, use other terms. Do you think the terms matter? And if so, in what respect, and how do they impact practice?
Yes, we come across many occasions where the parent who gets a residence order considers quite wrongly that that gives them complete control over the child. And there's also a lot of confusion. The health service, the education services tend to take this as wrongly as a view. The terms were removed in England in 2014 as the Spice briefing said to you. Canada in 2019 made the change, which will be implemented in the middle of this year. Our feeling is that names and nomenclature is important, and it is far better to have a term for a court order that is not implying that somebody has got the rights that they don't have, the control that they don't have.
So can I just explore that point a wee bit more, just to kind of tease it out? I can hear where you're coming from with the term residence order, for example, and as I said earlier, having previously worked in the field, I can actually understand exactly what you're saying in terms of the weight that's given to it. Can you explain how that's necessarily a negative thing?
I think it's a negative thing if a parent wrongly assumes that they have got complete control over the child's choice of school, over the child's health, and they therefore exclude that other parent from these aspects of life. Or the parent assumes that, well, I can move where I want to, I can do what I want with this child. It would be a fairly simple. We were very disappointed that it wasn't included in the legislation. We feel we would be keen to propose an amendment to bring this into place, and it's a very simple stage that I don't think has got many downsides, but could have a real positive, because what you call things is important.
Okay, thanks. Is it anybody else got a view on that?
Yeah, I have. I think that the terms, the term contact particularly is quite an abhorrent term to define a relationship that a child has with a parent. Would you, any member of the panel actually, would you define your relationship with your child as simple contact? It is much more than that. Children have a right to a relationship with both of their parents. It is an ongoing relationship that they have a right to. Children these days are not in that situation where typically their mother is a primary carer that raises them all the time. I live on a housing estate, and 40% of the children I see going to school are taken by a male carer. The world today is very different to how it used to be. It's very complex for children when their parents separate, and and the issue of saying that they live with one parent but only has spent time with another parent, or that parent even babysits them or looks after them, I think is quite an abhorrent concept. Children need, wherever possible, wherever safe, to have an ongoing, substantial relationship with both parents. And they live with both parents. They have bedrooms at both parents' homes. This is not about contact.
Again, I think that there's, I agree with the principle of your argument. I suppose just similar to what I asked Ian Maxwell is, you know, what suggestions would you have in place for a change? Because I see that in England and Wales it's called a child arrangement order, but I suppose we would ask ourselves the same question. We wouldn't call our contact with our kids arrangements either. So I don't particularly like the word contact, but I'm just wondering if there's a suggestion
I
in
tend
there,
to refer to parenting time. A quantum of parenting time, or I don't think it's an easy solution, but I think there is a hierarchy inferred in terms of residency and contact, which is unrealistic and not valid in today's society.
I'd agree with that point.
Word should be used somewhere in whatever title. And I think it's what you're saying about the child lives with both parents. That's only practicable when they live in the same geographical area. If the one parent lives out with the school catchment area, or even the county, the area of the other parent, a completely shared parenting experience is difficult time-wise, but that's not to say they shouldn't have contact in all the new technology ways that can keep the relationship alive, going, and spend a good bit of time with them. Again, it's an age thing, because younger children can spend all day with a parent. Teenagers don't want to. So a contact is not a good word, because it implies that you're only visiting. But parenting time is, for both children, equally valuable, because they've had parenting time with each parent while they've lived together. So to make a difference because they're separated is not good for the child.
Canada is going for parenting order. The suggestion we made was really to reflect that you already have specific orders, and we would suggest that this gets called a general order, so it takes it right out of it makes it more into a legal term, a general order, and then you have specific issue orders for particular things supplementing that.
Supplementary, Rona?
Yes, thank you. Dr Whitcomb, I wonder if you could clarify, I may have misunderstood this from your evidence, but you seem to be suggesting that while one parent's been investigated, contact should remain. Is that not a deeply dangerous position to suggest?
I think we have to understand that, as we've heard today, and as we know from criminal cases and civil cases and family cases, that sometimes allegations are unfounded. So again, I think what you're saying here is where your colleague was saying, do we err on the side of caution? I'm not saying that we should have unfettered contact in those situations, unfettered relationships in those situations, but we do recognise that it's important for children to have a relationship with parents, even parents who have been abusive. So in terms of public law cases, certainly in England and Wales, there's a statutory responsibility, even where a parent has been found to be an abusive parent, to maintain that relationship if it's all possible, because we recognise the importance of a child making sense of their experience, making sense of what their relationship has been and how we put that in place.
I couldn't disagree with you more.
Okay.
Thank you.
Could I perhaps ask about the welfare of the child, the statutory factors in section 1 and 12 in the bill, where various statutory effects are intended to guide the court when they're making decisions about the welfare of an individual, a child in an individual case. I think at present there's two main factors that are looked at. That's the prospect of parental cooperation, and then the need to protect the child from the risk of from abuse, or the risk of abuse. And these in section 12 two further are added, both in relation to court orders, one for the involvement, the effect the involvement of the child's parent might have in bringing up the child, and the effect on the child's important relationships with these people. Can you comment on that provision in the bill? Who'd like to start? Mr. Mann.
If I could start, the original Children's Scotland Act was a very clean and I think, better composed piece of legislation because it didn't have any lists, it simply had the 3 key principles. In 2006, certain things were added, and when this committee was doing its post-legislative scrutiny of the 2006 Act, there was some concern raised. The Dr. Barnes-McFarlane has also raised the issue about checklists. The UN Convention on the Rights of the Child has got quite a lot about this, particularly in General Comment 14. Her note was, if there is a checklist, getting it right is crucial. At the moment, we have a partial checklist. If we look to the UNCRC, it gives a suggestion for the things that could be included in the checklist. And it also makes the very important point that the checklist has to be expressed in terms of what is in the best interests of the child. Now, we would be arguing, for instance, that a rebuttable presumption of shared care would be something that should be added to the checklist, as it has been done in quite a lot of countries. Not because of the interests of the parents here. We're saying that, in fact, we will be adding it as a guide or as a starting point for the judiciary. If you ask the judges in Belgium, who changed the law in 2006 to include a rebuttable presumption of shared care, the judges say, yes, this is useful because it gives us a starting point. It doesn't force us to award shared care, and they only award it in maybe about half the cases that come before the court. But whereas at the moment, the starting point in Scottish courts tends to be a very tiny amount of care and then building up. And it means that the court has got sometimes to have the case coming back again and again to enhance the amount of care. Whereas if Scottish sheriffs are given a starting point of shared care, they're completely free from the evidence presented by the parties, to make a contact award which is either nothing or whatever is most appropriate. So we would feel that at the moment we've got a very messy piece of legislation that's got a partial checklist. If the Scottish Government is going to implement UNCRC, they need to take account of what UNCRC says about checklists, and we need to get it right.
Yes, thank you. Anyone else?
I don't have the bill in front of me, and I don't think I necessarily made a submission on this point. In England and Wales, there is a welfare checklist that is used by CAFCAS and CAFCAS Cymru when considering what might be in the best interest of the child. What I will say is that the welfare of the child is paramount, and we need to ensure that a child is safe, and that the relationships that the child has with anybody are safe relationships. But we need to have a proper assessment of that welfare of that child. And for me, there is too much emphasis on in private law proceedings where there are issues around safeguarding, where these would be better dealt with in public law proceedings. From my perspective, we should not be making decisions on what is harmful for a child in private proceedings. If there is a risk to a child, that risk should be properly evaluated and explored by the statutory agencies who are supposed to be making assessments of those risks, normally local authorities. I think too often we rely on parents to protect their children when actually it should be the safeguarding authorities who should be protecting children. So they should step up and say, actually, there is a risk here, and this is what should take place, that parenting time with this parent is not safe. But I think too often we rely on this in private proceedings when they should be in public proceedings.
Okay. And Ms. Loughton, if you have anything to add to this?
It's okay, Kate.
Yes, I noticed that, rather than a presumption, I think in your submission you refer to a right for grandparents. Is that correct?
No, not a right for the child.
A right for the child to see the
child.
grandparent.
Definitely not a right for the grandparents, a right for the child, because it's the child that's the important person in this bill and in life. The child is our future adults, so we need to get it right for them. But My concern with the right for the child is not necessarily in the extreme cases that are the go to the courts, the domestic abuse things, but excluding that, you can have parents separate and often, not always, the dad, his contact is reduced and the grandparents, the paternal grandparents' contact is reduced. The grandparent may have been picking that child up from school every day, may have been taking them to school every day, maybe have had them over the weekend, and all of a sudden, because the parents separate, the children don't get contact with their grandparents. Grandparents are hurt, yes, but how must the child feel that they've suddenly been taken away from people they've loved, they've trusted, they've spent time with, for no reason? So why should the child be traumatised like that? Because it is a trauma for them. A week's a long time for a child, a young child particularly, not to see an adult they love and care about. So months of court processes is just not practical. It's not in anybody's interest, least of all the child's. So there needs to be some kind of protection for these children to maintain relationships with family that they've previously had relationships with, not where there's been any issue of abuse or violence. That's a separate issue entirely. And our protection's already there to prevent that. It's to maintain the love and support that they have from family members.
In the shared parenting, I understand that's from the parenting point of view, then it's a presumption. But you know, this is phrased in the right of the child. Would it be more proportionate to say there's a presumption there will be contact, and then for the reasons you've explained, that sometimes there can be very good reasons why not, also very good reasons why, then that's properly explored. Would that be a more proportionate
if a presumption was going to give, if a presumption on the bill was going to give the child, well, can you explain to me what the difference to the child would be of a presumption and a right?
I can see the difference between a right and a presumption legally, in terms, and it does allow, in my view, could be wrong, but it does allow, in my view, for more of an investigation to take place and for the individual case and the circumstances to be looked at, rather than one size fits all. That's my understanding.
Part of the as we see it, the requirement for a right is when social work becomes involved in families, because over 20 years of dealing with families with contact problems, there's a huge problem when social work become involved in a family, because grandparents, it's kind of dependent on A, the area, and B, the social worker as an individual, whether they support the relationship between the grandparents and children. And it depends on whether, if a grandparent raises a concern. We've found it far too often that once a grandparent raises a concern about something the social worker has said, they are excluded from meetings. They're not told that meetings are happening. There's no proper investigation of what's being said or what a social worker puts in a report. If it's in a report and it's presented to a hearing or a court, there's no opportunity to question that or have that changed if it's wrong. So in our eyes, we see it as a protection from practices that are not as good as they should be.
Right. Would another way to look at it be to look at what happens in court and to see if there isn't that right?
That's part of the problem as well. But
for bad practice in one part of the country when things might be.
Absolutely.
Okay, that's an interesting contribution. Shona.
Good morning. We've touched on this already around child welfare reporters and curators ad litem. You may be aware that sections 8 and 13 of the bill propose to regulate child welfare reporters and curators. I would want to ask the panel whether you think that better training for child welfare reporters will be sufficient to address current issues. There was a comment made earlier on, I think by yourself, Dr Whitcomb, that you believe in a wider skill mix to be of benefit, and I can see other panel members nodding. So I guess it's just to get further on the record whether the appropriate professional background of child welfare reporters should be the focus for the reforms, and also when you're answering, if you could give us your view on whether the changes that have happened in England and Wales have delivered what they had intended to, because there's a suggestion from some stakeholders that the courts south of the border don't sufficiently prioritise safety concerns in their decision making. So if you could perhaps try and answer both of those.
I think the role that is taken by a child welfare reporter in Scotland is typically taken by CAFCAS and CAFCAS Cymru practitioners in Wales, who are all qualified social workers. And my personal opinion is that is a better skill set in order to take children's views and to do that role. Majority of my work is in England and Wales, but I have done some work in Scotland. And in viewing the child welfare reports that I've seen in Scotland, they've caused me quite significant concern, particularly the majority of those have been by solicitor child welfare reporters. My concerns are around the not understanding issues of coercive control, domestic violence, alienating behaviours, influence of a parent, how to take the views of a child. My concerns are around them not identifying what might be safeguarding issues and referring them on soon enough. My concerns are around the appropriate action recommendations not being made. I find it very difficult to understand how somebody whose core practice isn't around family relationships and the welfare and development of the child should be making recommendations on what should go forward. I find that quite a difficult concept, I think, to maybe that is because the majority of my work is in England and Wales, and I know that it's social workers doing that. There are certainly a significant number of cases that I have seen in Scotland in which recommendations made by child welfare reporters mean that the case becomes entrenched and stays in the court system for a long time, that inappropriate recommendations lead to an exacerbation of difficulties for the child and poorer outcomes for the child, in my opinion. And I have asked if I could make some suitably redacted bar reports available to the committee so that you can see what my concerns might be.
So just to be clear, your preference would be for the professional background of the
Yes.
rather than training available
Yes.
despite the professional background?
As a base level, yes.
Yeah. Okay, and what about any concerns from south of the border that I mentioned earlier?
I think sometimes there will be safety concerns raised about the decisions made by social workers in that role as family court advisors. I think what is important is a regulatory process and that we can deal with those complaints and deal with those concerns. I think there are similar concerns here in Scotland with solicitors doing the work of a child welfare
So it's less
reporter.
about the professional background, more about the decision making.
That's right, and to ensure that we have sufficient processes in place to deal with that.
Mm-hmm. Okay.
A comment about the English process. In the English family court cases, there is a fact-finding right at the start, which is an early test for things like domestic abuse, which is not present in the Scottish court system. And I think both ourselves and Scottish Women's Aid were quite interested in that as being a change that could be made, but that's more in court procedures. I would speak up. I also have had a chance to see quite a large number of child welfare reports. I've seen some very good ones and some very bad ones. So my concern, we don't want to throw the baby out with the bathwater. We have some good child welfare reporters operating in Scotland, but we have no effective oversight of these child welfare reporters. Nobody is looking at a sample of their reports, particularly when they're starting, but even when they're established, and trying to work out, is this good or not? There is very little control over how much they report. The changes we made as a result of the Bar Reporters Working Group have been good, because it means that the court does specify in far more detail what they want from the reporter. But I feel that there is a need to look at a wider, let's preserve what works well in Scotland, let's try and build from that into a better process where we introduce the skills of the child psychologists and the parenting therapists and the social workers far more into this process, alongside the evidence-finding abilities of the lawyers who do it. I mean, we've changed in Scotland. We used to have almost all social workers doing this. It's now almost all lawyers, and I don't think either of them were good. So we want training, we want oversight, and that needs to be worked properly, whether it's the Scottish Government overseeing it or the judiciary. I don't care, as long as it's done properly. But what I feel this bill is missing is the opportunity to have some potential to recognise that there are other key posts. In various submissions, you've heard both the mention of child rights officers, of which we have a few in Scotland at the moment, and of parenting coordinators. Both these categories of professional could take a very useful role and also take some of the load off the court. Because at the moment, in the cases that go back again and again to have child welfare hearings in the Scottish courts, a vast amount of court time is taken up with dealing with micromanaging disputes between parents. A parenting coordinator or a child rights officer could be working with the parents when these problems happen, not 6 to 8 weeks after the problem when it finally appears in court, and could try and solve some of these problems, and that would save us a lot of court time. We have very poor statistics on the Scottish courts at the moment, but I've made a guesstimate. I reckon that we have about 3,000 cases a year in the family courts in Scotland. We have about 10,000 child welfare hearings. We have 500 case management hearings. We have about 1,000 child welfare reports. Now, I don't think all of this should be happening in the court. I think some of it should be happening with professionals outside of the court, and I think there is a significant cost saving to be achieved here, which is just not recognised in the paperwork for this bill. So what I would hope is that the bill does lead to effective training and supervision of child welfare reporters, but it also opens up the potential for Scotland to experiment with far more use of both child rights officers and parenting coordinators, because I think they could really, they're a bit of the missing link here. And you may need in primary legislation, you may need the powers, even if you're going to do the detail at a secondary or an administrative stage, but you need the powers available within the legislation to actually have these people working under the remit of the court. The key decisions are made by the sheriffs and judges. The implementation of these things, some of it can be passed down the line. And sorry, I think, I'm not sure I've answered all your questions there, because I've
yeah,
yes.
I think so.
I just think there's a huge need for better training and understanding. The people who are doing reports or dealing with children and within the legal system as a whole needs to be looked at, because a lot of people are in roles trying to glean information and find out what's happening that don't have the experience or the knowledge to do that job. I don't mind whether it's legal people that do it or social workers that do it, but the person needs to know what they're looking for and get the correct information.
Okay.
To be very, we're already well over time, Fulton. Can it be very brief?
Yeah, it was a supplementary, actually, convener, on your question and also on Shauna's. It was just in relation to June Loudon's point. I just would firstly say I don't fully recognise the description of social work in that aspect, because I do think that grandparents are often lifesavers in situations of high stress for families. But I do think you raise an overall good point. Sorry, convener, I will be brief. I do think there is a point in there. I think the point that you're making is that the children's right to contact with grandparents, which I know myself, having 2 kids, is very, very important for young people, often is sometimes lost as a byproduct of another matter. And I think that if children were involved in the children's hearing system, that would be assessed. So if the children were both involved in that, there would be an assessment, there would be more work done, grandparents would possibly be invited to children's hearings, so there would be more safeguards there. I think what you're talking about is when kids aren't in those specific systems, can then, therefore, do you think that a child welfare reporter, part of their job should be looking at the extended family and where important relationships lie for the child? Apologies,
The evaluation of the whole situation, but going back to the biggest volume of our calls come from grandparents who are not involved in the legal position, other than that their child has separated from their partner. And a grandparent, a child has a right to claim on a grandparent's estate when they die, should their parent predecease them, but they don't have a right of contact in life. So is money more important than time? Is your estate of more value to your grandchild than your time during your life? There needs to be some kind of an equality thing there. Is it good for a child to have contact with a grandparent, or is it not? And you need to make that decision, and if it's in the best interest of the child in one way, it's the best interest of the child in the other way.
Thank you for that. Rona.
Thank you, convener. Yes, my question is about child contact centres, and that comes up in section 9 of the bill. And I think I could just have brief answers, and because we are really short of time now. Do you think that courts should, as a matter of principle, be ordering contact in contact centres, where by the very nature of it suggests that supervision would mean that it's not particularly safe for the child? Do you think that's still reasonable to do that?
I think the contact centre can be good if contact has been broken for quite a wee while, just through the slowness of the court process. And sometimes in a contact centre, when there have been accusations that he doesn't want to see the parent, or he doesn't get on with the parent, or whatever, if there's contact there, there's an independent person monitoring that contact, and it can be positive for the child if it's done in the right setting with the right regulation of that contact centre.
Anyone else?
We hear a lot about contact centres, and we hear some very positive things, also some complaints. And I think, again, thinking about it from the point of view of the child, if you tell a child you cannot see that parent, that child is half the genetic makeup of that child. You're telling the child that half of them is a problem. Now, there needs to be, we need safeguards, we need protection for children. We want to make sure that children are not exposed to harm. But to cut a child off completely is a difficult decision to make. It's one that's got to be made on absolutely clear grounds. And as June said, sometimes the contact centres are a good way of protecting a child and allowing a child to see a parent in situations which otherwise would not be at all safe for the child. I've read some of the evidence that's been submitted to the committee about problems with contact centres. I only see one side of this, but I would certainly say from our point of view, contact centres are a really important resource, and we should certainly not, we should develop them and build them up and make them better.
Thank you. Dr Whitcomb?
My experience of child contact centres are used for several reasons, both in public and private law cases where space is needed to allow contact to happen between children and parents, children and grandparents, children and siblings. Some of those cases are cases in private law proceedings in which there has been a disruption to the contact, the time that a child spends with a parent, where there is no evidence of abuse. And the contact centre is used to build up that relationship again with the parent in a safe space. Sometimes there are situations where supervised contact has been ordered by the court, where there may be concerns about a parent, or there may be in a situation where those concerns have not yet been evaluated in order to maintain that relationship while that is going on. Again, I know you disagreed earlier, but there are situations where there are allegations which aren't founded, and it is important to maintain that relationship with the child in a safe manner. And I think that child contact centres offer a safe environment in which contact can happen.
Okay, thank you.
And Liam Kerr.
Thank you, Convener. I'd like to finally just look at enforcement of court orders. When a court order is breached, Section 16 of this bill would impose a new duty on the court to investigate why this has occurred. Now, some evidence to this committee suggests that this adds little, but others have told us that it doesn't happen now as standard, so it's absolutely required. I simply seek the panel's views on that, and in any event, if this is brought in, should the views of the child always be sought?
Yes. We've proposed a range of ways in which court orders could be enforced. The suggestion in the bill that the circumstances be examined is a good one, but I think the sheriffs need a lot more than this. I was interested to see that the Sheriffs Association said that they would welcome a statutory scheme for simpler regulation of contempt cases, a fast-track minute and answers, so that this would be to establish why things have happened. And they're suggesting that rather than sending off the child welfare reporter, because in minute and answers you could actually find out right here, rather than spending weeks, if not months, trying to use the reporter. A framework for a social work report, if necessary, to find out circumstances why the contempt, why the court order is not being carried out. And sentencing powers, including community payback, requirement to attend parenting classes, and what's most important, deferral of sentence, because I've been in cases where the mere fact that contempt has been established has been enough to restart the contact, because the parent realises that the court order was serious and that child should see the other parent. Sheriffs are often using this, and quite rightly, sheriffs are reluctant to imprison parents, and I agree with what was the comment that came from Marsha last week, that imprisoning a parent because of contact, but there are a lot of very community service orders, parenting classes. These are positive measures that might actually improve the situation.
Yeah, yes, they should always be investigated, and yes, the child's views should be taken into consideration. I would like to look at some of the evidence that's previously been provided by Professor Sutherland and Dr. Whitecross, who talks about particularly intractable cases where cases keep going back to court and there seems to be no reason, but one parent keeps refusing to abide by a court order. And I think their comments were that there is no solution to these problems and the court can only do so much. My concern is that it's a failure to identify the harm that behaviour has on a child. If a parent continually disrupts and prevents a child having a relationship with a good enough loving parent for no reason, that is harmful to that child and that can be considered to be abusive, and that needs to be taken into consideration.
Ms. Loudon? Yeah.
Yeah, I definitely think there needs to be an investigation when contact doesn't happen. It may be that there's been abuse that hasn't been raised before, but that needs to be confirmed if it hasn't been raised before. It could just be vindictiveness. It could just be anger that hasn't been dealt with. There's a multitude of reasons why it hasn't happened. It could just be to get at the other parent. And a lot of parents may do that not realising the harm that it does to the child. So that needs to be investigated and in some cases just explained that, you know, it's not the husband or the wife you're getting at, it's the child you're getting at. So I think investigation is very important.
Thank you. Our last question from James.
Okay, thank you, Convener. Briefly, Section 21 of the bill deals with court delays and says that basically where there is a court delay, the court should have regard to the welfare of the child and take action to ensure that the cases are basically speeded up. Just briefly, do any of the panel feel that that provision doesn't go far enough and it needs somewhat strengthened?
I would agree that it needs strengthened because the experience at the moment, we've had Supreme Court decisions, we've had judges from the Inner House in appeal cases making pronouncements. Lord Emsley saying that contact decisions should take place in weeks, if not, or at most months. I've been in court in front of sheriffs and I've quoted that and they've just disregarded it. They've not taken any account of the fact that this, and they've then ordered a report which is going to take 2 months or something like that, and not put in any provision for contact in the meantime. I'm afraid that the urgency of hearing cases is important. We quoted in our evidence the work of Judge Rudolph in Cochem in Germany. He instituted a scheme in his local court where if an issue was raised, only 1 page of paper from each side should be submitted, and there should be a hearing within a week or at the most 2 weeks to consider it in court, and if necessary another hearing in another 2 weeks. And that worked in Cochem. That progressed a lot of cases in a way that benefited the children rather than having to wait months for some decision on a fundamental aspect of their life. I feel that the delay in cases in Scotland is a problem, just simply because that's the way that the courts work. And if you're dealing with a fraud case or something like that, maybe it doesn't matter if it's taken that long, but it is really important in a family case that the court sits early and considers it, and considers whether it's safe for the child to see the parent, considers whether the arrangement should be made, and that should be done quickly, not after. And although I know that work is, I was involved with the group on the Family Law Committee of the Civil Justice Council looking at case management, and we, there are changes in case management that are being considered, but my feeling is that we need a far more fundamental emphasis on speed in family court cases because that's important for the children concerned.
I'd like to come in. The delay for children is extremely damaging. A week in the life of a young child is an extremely long period of time, and a month is so much more. In England and Wales, they did introduce guidelines in private law proceedings that the case should be heard and dealt with within 18 weeks. And they introduced guidelines in public law proceedings that the case should be dealt with within 26 weeks. I'm not saying they're always adhered to, and I'm well conscious of the fact that the cases that I'm normally brought into have been in the courts for 1 or 2 years, sometimes 3 or 4 years, and sometimes they've been back and forth to court for a period of 10 years. And that process in itself is extremely damaging for children.
Okay. Anything further?
No, I just think that it needs to be speeded up for the same reason as Dr Whitcomb said a moment ago, that a week is a long time for a child, never mind a month or a 6-month period. It needs to be looked at in depth, looked at properly, investigated properly, and a decision made in the best interests of the child.
Okay. Thank you very much. That concludes our questioning. The session has gone on much longer than anticipated, but it was important that we got all of your views fully and you had the opportunity to express that, which has been very helpful. During the course of the evidence, you suggested there be further information you could provide the committee with, and we very much look forward to receiving that. So in the meantime, thank you all very much for attending. Now suspend for a change of witnesses, but a 5-minute comfort break. I welcome the witnesses for our second panel this morning, Stuart Valentine, Chief Executive of Relationship Scotland, and Isabel Bilsland, Manager of Relationship Scotland Borders. And can I thank the witnesses for the written submissions, which are also very helpful, and also take the opportunity to thank you for hosting the committee when we had our away day in September. Right, we now move straight to questions from members, starting with Jenny Goruth.
Thank you, Convener, and good morning to the panel. As the panel will be aware, Section 1 of the bill would remove the 12-plus presumption in terms of taking evidence or views from a child. And in your own written evidence, you note that our concern with removing the age presumption was that children's views would be less likely to be taken. I wonder, therefore, if Relationship Scotland are now supportive of the removal of the 12-plus presumption.
Yeah, just to say we're certainly very supportive of children having the opportunity to give their views. We do know from the children who come to our centres is that they're very keen to be heard, but it's helpful for them to know that they're not going to be the decision makers in this, that the responsibility for the final outcome can rest with others, but children have the opportunity to be heard and to be listened to as part of the process. And we think that is vitally important. We would hope to add that there would be details in the final act about the different ways that could be done. We do have within our own network, around half of our mediators are trained to consult with children through the mediation process. There may be many other ways this could be done as well, and we think it would be helpful if the bill were able to, the Act would be able to specify the different ways that this might be done in the future going forward. We do, within our areas and borders, where colleague Isabel works, and in Aberdeen, we've also developed more work in that, and I think it would be helpful to hear from Isabel about that work.
Yes, apart from just hearing children's views where their parents are in mediation, we actually hear children's views in quite a variety of ways. Most of these are court-ordered, and they ask us to try to ascertain what children feel about their family situation and what they want to see happen in the future. We tend to see children over a period of time. It's a process. It's not just a one-off meeting, because children, especially younger children, have got to feel comfortable with who it is that they're speaking with. And like I say, with young children, we would do a variety of activities, and it might start off with literally just card games or any sort of games to try to ascertain the views. And the court is asking for us for these views in lots of ways, and it might be letters written by the children, and we could support them with that. It might be supporting the children to speak with the sheriff or with a solicitor, or it might be that the court asks us to just try and ascertain the views ourselves from the child and then write a report for the court. So there's all manner of ways that we're doing that work, and I think that's quite important.
And just add, of course, that if it's with younger children than the age of 12, then about any methods to take their views being age appropriate, of course, to make sure that's done in a reasonable way. We do know that the Family Justice Modernisation Strategy indicated the Scottish Government were considering some system of child support workers, and that's again something that we would support if they were specially trained in terms of taking the views of children.
Just to follow up on that line of questioning then, Stuart Valentine, in your written evidence, you mentioned both the importance of child consultant mediators and child support workers. Do you think these roles are quite distinct and separate? Would you ever consider that a child consultant mediator could become a child support worker? And I guess the context for this is the Scottish Government's desire that a child doesn't have to see a various, duplication of lots of different individuals, that they're just seeing one individual. How does that work then? In that context.
This could certainly contribute towards that. As I say, around half of our mediators are trained in consulting with children, and certainly our network would be open to being more involved in that work.
Okay, but they are quite a distinct role from being a child support worker, for example?
Yes, that would be different.
Okay. And lastly, I guess we considered in the previous panel taking evidence from very young children. I think, Isabel, you alluded to that in your answer to my first question. I just wonder if you have any more views in terms of how that evidence could be best gathered from very young children in particular?
I mean, really, it has to be on a case-by-case basis. I mean, just now we're working with a boy who's actually a teenager, but he's got a very young outlook on life. And really you can't say that a child of 10 will be able to do X or Y. So a prescriptive list, for example, we wouldn't be supportive of. But like I say, we would always ask the child how they feel and how they would feel most comfortable reporting back their views. And we would tend to go along with that. And like I say, it can start off with games. And actually, sometimes when you get into the nitty-gritty with children about how things have been for them and what the difficulties that they're facing are, if they get quite distressed, we can pull back and go back to maybe more of a sort of generic game with them rather than some sort of game that might be trying to find out what their views are.
Thank you.
John.
Thank you, Gavina. Excuse me. Good morning, panel, and thanks for your evidence. As regards the actual centres and the staff, we know from your evidence that you have voluntary and paid staff. Are you able to tell us how typically a mixture would go, what the specific roles would differ between the two categories of volunteer and paid, please?
Certainly, yeah, we do know. We just, in terms of most recent figures, we have 152 paid staff within our child contact centres and 128 volunteers. The direction of travel in this is more towards paid staff, so it used to be we'd have more volunteers proportionally in the past. Is definitely the direction of travel towards more paid staff. So in terms of the proportion, that's the case. There's also many different roles within our child contact centre. So for example, you would have people who would be involved in the intake process, making those initial assessments and gathering all the information of the case. You have volunteers within the centre, you have child contact centre managers, and then you also have the overall service manager, of which Isabel is one. So there's a whole range of different roles within the centres, and also, I guess, different levels of experience and training depending upon what those roles are.
And can I ask about training? For instance, there's been a lot of reference, I think perhaps you were in this morning, heard about many references to domestic abuse. The domestic abuse legislation was passed, and an important element of that was the controlling and coercive behaviour. Is that something that your staff are aware of and have training on?
We would be sending our workers, staff and volunteers to the local authority domestic abuse training on a rolling programme. But also we would be doing that training in-house as well and updating training as well as we go. And they all welcome the training, actually, everybody who works for us.
I'm sure. And can I ask then, having received that training, are any of your staff aware of anyone within the centre seeking to use controlling and coercive behaviour in the process of contact?
Well, yes, that's a short answer. I think they are. But you know that we, in the contact centres, for both supported and obviously for supervised, we keep the parents separate. That's one of the whole things about contact centres, is that the parents should never meet. And so, you know, they are aware that there's maybe someone trying to pull the strings or control what's going on. But within the contact centre itself, it doesn't happen because they're kept. They're kept apart. We have separate arrival and departure times. They have quite often a separate entrance, and if they're not, they've got an entrance, you know, one parent's kept somewhere else where someone else is coming in. And so they should never catch sight of each other and never see each other. And we get the position where one parent will say, can you pass this on, or can you whatever, and it's not an appropriate setting to pass bits and pieces on, unless it's something like, oh, the child's had a cold this week, you know, these sorts of things. Can you make him or her aware of that? So they maybe need something, or they maybe need that. That would be the only sort of messages we would be passing on in the contact centres. We have become aware, sorry to go on, we have become aware of, for example, someone trying to put something in a child's bag before the child is then taken back to the resident parent. And, you know, we've caught that before it's gone through, and you know, because we don't know what's in that. That could be some sort of abusive letter or whatever. So we try to be quite careful.
Yeah, just to briefly add, I mean, linked to this, and maybe we'll come on to this, but the whole issue about the decision of the courts in terms of if contact is ordered, we also, in addition to that, make our own risk assessment. So there needs to be the assessment, of course, of the courts in the cases when they come to them, but also our centres make our own independent risk assessment about whether cases are safe to progress as well. So many of these issues hopefully will be being picked up on the risk assessment. And it's also worth saying that it's not routine, but there will be cases where the court may order contact to take place, but our centres will make the judgment that we don't think that it's right and proper to go ahead with that. And there will be cases where we will say, no, in our view, we can't safely facilitate this contact, and we will not go ahead with it.
Thank you. And are you able to comment on the prevalence of domestic abuse as a proportion of the workload, or indeed other serious welfare considerations?
I think in general terms it would be, I think around about half of the cases that may be mentioned as an element there, and clearly that's something that's vital for the courts to make a judgment of. It's something vital for our centres to make a judgment on. I mean, we do know, of course, that Scotland continues to have a very serious and significant problem of violence and coercive control, predominantly but not exclusively from men against women, and that's something that is of vital importance to our child contact centres and how they run. It's in no one's interest for unsafe contact ever to happen. We do not want that to happen in our child contact centres, and the safety of everyone involved in it is our first and main priority.
Thank you. Well, and finally, if I may ask about the source of your referrals and how that affects the work that, the characteristics of the family and the work that would take place.
Across the whole country, so we have around about 2,500 children come to our contact centres each year. We facilitate over 32,000 separate contact sessions. Those referrals come from mainly from the Scottish courts and from solicitors. So 80% of our referrals come from the courts and solicitors. You will then also have referrals from social work, and also there'll be self-referrals as well, but the vast majority come from the courts and from the legal profession.
And does the source substantially affect, well, I mean, each case will be individual, I'm sure, but does that affect the range of work that you're required to undertake generally?
I would say that we get very few self-referrals where there are significant concerns, whether that be mental health issues or there's been a history of substance abuse or something like that, or domestic abuse, really. I think most of those types of referrals come from the courts, would you say, Stuart? Yeah. And we do get some from social work, where there's maybe mental health or substance misuse or something.
Yeah. And a key theme over the years, certainly the past 5 to 10 years, a key theme is the increasing complexity of the issues that people are presenting with in terms of drug and alcohol misuse, mental health issues, self-harm, suicide, ideations, a whole range of different issues that are now, I guess, coming into our services for us to deal with. And there's a big increase in that as time goes on, which can make the arranging, the facilitating, just making sure good positive contact takes place. That's an additional challenge with these other issues that the families are experiencing.
Okay, many thanks indeed.
Supplementary, Liam?
Convener, good morning. I should declare an interest as my wife is a mediator with Relationship Scotland Orkney. Just following up the line of questioning from John Finney there, you indicated that there are occasions, albeit very rare occasions, where you don't consider engagement through the contact centre would be appropriate or safe. What tends to happen in those cases? Because it's difficult to imagine if it was not possible under supervised conditions within a contact centre that there would be any way of facilitating that contact safely. Does the court simply accept a view from Relationship Scotland that contact in those cases simply cannot be safely facilitated?
I would say that it's mostly the case if the courts send them for supported contact, and then we feel that actually having done a risk assessment and perhaps hearing other pieces of the jigsaw puzzle, if you like, through the MARAC system or whatever, that really that wouldn't be safe, then we would go back to the court and say we're really only willing to do some supervised contact, at least in the interim, until other things are sorted out through the courts or whatever. And yeah, the courts, it is rare, but the courts have accepted that.
Okay, that's helpful.
Fulton.
Thanks, Convener, and good morning, panel. Just following up from Liam MacArthur's point there, and also something Stuart Valentine had said earlier around about who is it that makes the decisions around contact the court or yourselves. Would you be able to explain how that might work in practice? So say, for example, as Liam was saying there, a court order comes in and then you begin to assess the family dynamics and circumstances. Are you able to take us through a sort of an example of how that would work?
Yeah, sure. The norm would be we would get the court referral and we would get some information from the court, and then usually what happens is that both solicitors will phone us up, or if not, we will phone the solicitors and try to get a bit of a... And sometimes it doesn't sound like the same family you're dealing with, because you get two very different stories. But it does give us something to start on. And sometimes we will be aware of the family because they're already working with us through other routes or whatever, or like I say, through the MARAC system. But then we would do initial assessments, initial interviews with people, just taking their views, telling them how this system works, and usually at that point both parties will give you lots of information. We will do quite a simple, if you like, trawl to make sure if there's any domestic abuse issues coming to us, mental health issues, all these sorts of things, child protection issues. And if anything at all is flagged up by anybody, or, you know, from another agency or from the parents or the solicitors or the court, then we would do a much more in-depth risk assessment at that point. And that may be that a senior person from the service would do that risk assessment. In our case, that would probably be our family support worker or whatever, and they would go into things in much more detail and perhaps be phoning up agencies such as Children First or Social Work Department or Child Protection Unit, these sorts of things, and just making sure that we've got as many boxes ticked as possible. It isn't always possible to get everything black and white because, you know, if it's not gone through the court that there's a problem, it's not going to always flag everything up, but we do as much as we can.
And how prescriptive are court orders, how prescriptive do they tend to be? Because I suppose why I'm asking that is if you are confronted with a situation where a court order says, you know, X, Y and Z, and you know, your expertise in the area, immediately there's some warning signs for you there, and you don't have time to get back to court, it's maybe over a weekend or whatever. You know, is that just a referral to the statutory agencies, or do you deal with that yourself? Or?
Well, the fact is that the way you'll get normally court, the actual order from the court, the interlocutor, is usually pretty slow in coming through. But the sheriff, clerk, or usually the solicitors will get in touch with us that day or the day after. So we've got lots of warning. But there are times when they say we need 3 supervised contacts done and we need the report by whatever. And we just say, well, we can't do that. That's not possible. So they will actually continue the case or assist the case or whatever and move it forward. Because to the court, it's more important that, you know, we go through and all the boxes are ticked and everything is done. Rather, there's no point just going back to court with, you know, 1 contact if they think that's not going to be good enough. Does that answer your question?
Yeah,
yeah.
That's good.
Okay.
Maybe just adding, there is at times gaps in the information that our contact centres get from the Scottish courts. So often they don't get the full picture, and there's a task of our centres to try to make sure that they get as much information as possible. And we certainly think that's a weakness in the process, is that the courts are not giving a full picture of all the circumstances that we might best be aware of before we go ahead with contact. And we certainly think that's a gap in the process that could be improved.
I think it's in some areas more than others. Some court areas seem to be quite happy to give more information than others. I think there is a problem in some parts of Scotland.
Yeah, and I'd like to think as well that there would be a degree of flexibility, given that you're going to be dealing with the COVID, and you're dealing with families in very difficult circumstances often. So, you know, you need to be flexible to react. Just one more question, Convener, if that's okay. You talked earlier about the staff set up at the contact centres in terms of paid staff and volunteer staff. When you're dealing with certain situations, is there different status of staff required for different types of contacts, or is everybody, you know, operates in the same fashion?
Yeah, people will be trained appropriately for the task that was being undertaken. So, for example, if we're doing supervised contact, which is a more intensive oversight of what's happening, people would have additional specialist training to undertake supervised contact in terms of the contact itself, writing reports from the court, the range of issues that they would be dealing with that. So certainly people are trained appropriately to the task that they would have, and in some activities we would do would be more intense and would require higher training than others.
And is that more likely then to be the paid staff that would do that, or not?
Yeah, that would only be paid staff that would do supervised contact.
That's fine. Thanks.
Can I just say, always a paid member of staff who takes responsibility on the day for the contact centres.
Could I just add very briefly, just one issue that again may come up, but the issue of when the courts are making decisions around contact, a gap that our network sees is that we think there should be specialist risk assessments that the court would be able to have access to make the determination of issues like domestic abuse, coercive control, and at the moment the court doesn't have access to this specialist knowledge, and we would be very keen to see something like specialist risk assessments being made available to the court. There have been a very small number of these assessments done in Scotland. There's a number of people who are already trained, and again we see this as a particular gap in the process. As I said before, we do not want unsafe referrals be made to our contact centres from the courts, and specialist risk assessments would greatly assist the court in making their decisions about when it's safe for contact to progress and when it's not safe.
Thank you, Convener. Mr Valentin, just a brief... there was reference made earlier to MARAC assessments, the multi-agency system. So how would what you're suggesting not meet the terms of that, or where does it fit in the scheme of things, please?
Well, the fact is that Relationship Scotland services don't work within the MARAC process in every part of Scotland. It really all depends on the local authority that you're working with, whether or not they include, you know, which agencies are included within the MARAC process, I think.
But if I may, presumably a local authority who don't include you in their multi-agency risk assessment process wouldn't make a reference to you through their social work department that wasn't supported by a risk assessment if someone was the subject of a MARAC assessment, if you follow me.
Yeah, I'm not sure the best answer. I mean, the referrals would come from the courts. So if the courts were making direct referrals to our contact centres, that may or may not include in certain parts of the country that link to MARAC. But
you said you also got referrals from social work services as well.
Yes. We get some, but not very rarely for supervised contact. That would only really be for supported contact. We do get some for supervised contact, but very rare. The ones for supervised contact that come through that I have experience of, to be honest, is coming because it's either looked after children who are maybe with foster carers, or there's perhaps a child with maybe with Asperger's or something like that, where there's a special need required that they're coming via the contact centre for.
The reason I ask is to understand if there's shortcomings in the bill that we need to pick up on, because everyone would want to put a very high profile on the issue of safety. If there's something you felt we should, or give examples, you could perhaps write after.
We'd absolutely provide more information about our thoughts around specialist risk assessments that could be available to the courts. Absolutely, we'll provide more information on that point.
Thank you very much.
Helpful. Thank you. Rona.
Thank you, Convener. Good morning, panel. Yes, just in light of your responses so far, I wanted to sort of wonder if you could clarify who actually is responsible for the children. In your written submission, you say that one of the principles of contact at your centres is that it's parents, not staff, that are responsible, and that contact centre staff have a general duty of care in respect of its premises and its users. So could you maybe clear that up? Because what we've been hearing is that you are taking a lot of responsibility for safety measures, etc. So could maybe just elaborate on that.
Absolutely. If I could say the general points, and Isabel maybe fill in some of the detail. So in terms of whose care would be, it partly would depend how it's done. So we do a range of different types of contact in our centres, ranging from handover, where basically one parent would bring the child to the centre, the child would go through staff members to the other parent, the parent then may leave the centre for a number of hours and come back. Now, clearly in that circumstance, the responsibility for the child remains with the parent. It would be very similar with supported contact as well. Supervised contact, there is, as I say, a much greater oversight. There will be a worker observing and taking great care during the contact at all times. So there's clearly a lot of responsibility there. But at all times that families and children are in our centre, there's the oversight there. But it is a facility for people, for children to spend time with their parents, and there is, if it's been deemed safe and if it's going ahead with the knowledge that this is a safe process, this is about also the parent being responsible for their child during the time of contact as well, in the confines of being in our centres and having staff present around the centre as well. And should an incident arise during contact that becomes of concern, are you confident that your staff can intervene? Are you contacting the process that will keep the child safe? And does that happen often?
Yes, it does happen. And it can happen in a very low-level way, in as much as a member of staff will go forward and say, could you, we want you to come out the corner because we can't see what's happening here, or this is, do you really think that's appropriate to be speaking with your child like that, or you can't take photos like that because it's, intrusive or whatever. But it has happened in ways where we've had clients in contact centres who have really behaved in a totally inappropriate way, threatening staff or whatever, and staff have had to intervene, call the police or whatever, and actually take the child away from that parent. And in that case, they have to take responsibility for the child until the other parent can be brought back to collect the child. And we also have had incidents when we've had, and it is quite sad, you might get a mother who comes to see their child who has, mental health issues, and they're not handling the child appropriately, they're trying to force feed the child or something like that, and staff have had to intervene at that point as well.
How much of that, I mean, just on a very rough basis, is it few times, 20%?
One thing I would say is that is growing all the time. I mean, at one time, I would have said 10 years ago, it was happening once every 6 months. Now I would say, and I can only really speak for my own contact centres, I would say that that's happening once a month.
Okay, thank you. Just my final question is really the one I posed to the other panel. So given that if contact has to be supervised, by the nature of that suggests that there is a safety risk, do you think the court should be ordering it at all?
I think this goes back to the central dilemma here is about whether parents are able and should be able to continue to have a relationship with their children. We do know from research that between a quarter and a third of children lose contact with their non-resident parent after separation and divorce. In the vast majority of those cases, there's no good reason for that, but clearly in cases where there's domestic abuse, coercive control, issues such as these, there has to be a judgment made. We are calling for, as mentioned previously, for specialist risk assessments, but we're looking to try to ensure that courts and others make the best decisions possible. But it's the wisdom of Solomon as to whether or not contact should go ahead. You've heard a range of different views from different organisations about, I guess, where the balance should lie with that. It's an enormously difficult decision to make for the courts and others to make these decisions, and it's about all of us jointly, from the bill, the new act, the organisations who work with these families, to try to make the best judgment as possible for the best outcome for children. It's a massive loss to a child's life to not have a relationship with one of their parents, but in a number of cases, a significant number of cases, that may be the best outcome, but it's an enormously difficult decision to make, and that, I think that is clearly the challenge before us.
I think it's important to say as well that supervised contact happens for a variety of reasons, and not just because the court feels that it could be unsafe.
What would they
Sorry.
be?
Okay.
What would they be?
Well, quite often it's because a child hasn't seen a parent for a long time. I mean, just about 3 weeks ago, we had a child coming into the contact centre, hadn't seen his parent for 2.5 years, because he had said he just refused point blank to see his parent, and even outside the door of the contact centre was saying, I don't want to see my parent, I'm not going in, I'm not going in. And then all of a sudden he said, well, I'll just go in, but I'll tell him I don't want to see him. He went in. As soon as he went through the door, he just ran straight to his other parent. And the contact lasted for 2 hours, and it was a very positive contact, and it was there was we had no concerns viewing it from that angle. But there's also issues like, for example, a parent has changed significantly, like they've maybe been in the army. We've had them who've been very badly disfigured in Afghanistan. The parents are separated, so it's not able to reintroduce that parent in a different way to their child through a family setting. So we've worked with them to try and say, well, this is still Daddy. Daddy's not able to hold you anymore, or whatever. So there's a lot of reasons why.
In the incident you talked about with the child not wanting to go in, did that not concern you at that point? Did you feel obliged to take that child into contact when they clearly didn't want to?
Never force a child into contact.
Saying he didn't want to go in?
He was. He arrived outside, and his mother was there saying, well, why don't you just go in for 5 minutes and see? Why don't you just, nobody was saying there was at that point any reason why the child shouldn't see their father.
Does this not go back to the whole purpose, core of listening to children's views? If they say that, you have to believe them?
Yes, I agree. This was the first time we'd met this child. We'd never, the child hadn't been in our service, we hadn't been speaking with them. So, the mother was very encouraging and saying, I think you should go in and see your dad, just go in for 5 minutes. And, we would be saying, if you want to come in, this is what will happen. This is where your dad will be sitting. This is where you'll see him. We'll be with you all the time. Your mum will be waiting in this room. If you want to go and see your mum anytime, we'll take you right through. If they want, they can give us safe words that they'll say, or a safe action, so we would know to take them out the room at that point. The mum seemed to be sure that the child actually did want to see their parent in this instance, but I would like to just reassure the panel that we would never, ever try to force a child. We've read things that say, the child was taken screaming away and dragged them, them in. Well, that is unrecognisable for us. It's not something that we do.
Thank you.
And James.
Just wanted to touch on the position. Just hold in regards to funding. So one of the issues and one of the challenges that is faced is the big lottery funding is going to be withdrawn on March 2020, £750,000 a year. So how do you envisage trying to overcome that challenge?
That's a very good question. The Big Lottery have provided excellent support to our child contact centres over the past 5 years. We've been very grateful for that support. The Big Lottery themselves have less funds than they used to have, and they've advised us that they're no longer able to fund us from the end of March this year going forward. There's very few funders in Scotland that can provide that level of support. There really is only the Big Lottery and the Scottish Government. We have been in discussions with Scottish Government ministers now for a number of years, highlighting this issue that will come up at the end of March. And we were very pleased to get the news just before Christmas that there was going to be interim funding for 3 months from the 1st of April until the end of June of £200,000 to support our child contact centres during that period. And that will also allow time for us to continue to speak with ministers and officials about the longer term sustainable funding of child contact centres, which we certainly feel needs to be in place. We do need, stating the obvious perhaps, we do need funding to run our child contact centres across Scotland. As I say, we're having 32,000 individual contact sessions a year, and that needs to be supported by staff and premises and other support going forward. The main route we are looking to right now is to the Scottish Government to provide the majority of that support going forward in light of the loss of the Big Lottery funding, and as I say, those conversations are ongoing just now.
Are there any other sources you've been able to investigate separate from the Scottish Government?
Absolutely. I mean, essentially across the country just now there's a sort of funding jigsaw in place. So already we receive funding from the Scottish Legal Aid Board, from charitable trusts, from donations and charges that can be made. There's a range of different sources where we get our funding from. We've recently provided very detailed information on that to the Scottish Government. So there are and will continue to be a range of funding sources for our contact centres. But what we would not be able to make up would be a loss of £750,000 in Big Lottery funding. We would not be able to make that up through, for example, a range of applications to other charitable trusts across Scotland. It's just not feasible to bring in that level of funding. So we've made the Scottish Government aware of that, and we continue in our discussions with them, hoping to find a way forward to find sustainable funding for our services.
Okay. Shona.
I just want to touch on referrals, excuse me, to the courts from other sources. I think Isabel Bilson, you mentioned this earlier on about sometimes there can be referrals from social work and there are issues around substance misuse or mental health that haven't come through necessarily the court system. You say in your, the bill requires referrals from the court to be in a regulated centre, but if it was referrals from other sources, that wouldn't be the case. But in your submission, you think it would be impractical for Relationship Scotland contact centres to operate in this way, and it would be useful just to hear a little bit more about why you think that.
I think we wouldn't really support a two-tier system of child contact centres. We operate and support 42 child contact centres across the country, and they operate in an integrated way with their other services. We try to have as great a geographical spread across the country as possible. That's very key, so families don't have to travel too far to access contact. And I think going forward, it wouldn't be practical to have I guess, two different standards we work to. We've worked over the past 30 years to develop very strong standards, policies, ways of practice across the country, aiming for the best practice everywhere we operate, and we would continue to want to do that going forward. So in our view, it wouldn't be practical to have, I guess, two types of child contact centres across the country, one that meets the good high standards of regulation and another network that doesn't. We think all should try to attain the best standards possible.
Okay, it's clear. Thank you.
In your written submission, you refer to a gold standard for accommodation for contact centres. Could you elaborate on that?
It's interesting. I mean, our contact centres operate in different places, so it may be they were within our own offices, the centres we operate. It may be, as in the case in Hamilton, for example, we run a child contact centre from the Burnbank Family Centre, a specific already established family centre that we would then use those premises at part of the year, part of the week. And then across the country, it may be in church halls, it might be in community centres. There may be just ad hoc places that we use around the Highlands and Islands in terms of just using centres now and again when a contact's required. There's a whole range of different premises. What we'd be keen to avoid, I hope, through regulation is that it wouldn't be the case is that some of the centres that we have to use from time to time are not going to be allowed to be used because of regulation. We'd be hoping for a sensible, flexible approach that would make sure that all centres we use, of course, are safe and are right for purpose. But we wouldn't necessarily need every centre to, for example, to have disability wheelchair access at every centre. That would not be something, in our view, would be necessary. What we could do and what we could guarantee would be any cases where families come to us with those needs, that we would find a tailored solution for those families, so no one would be, it wouldn't be to anyone's detriment, but it wouldn't necessarily be the case that we had to have every centre, for example, with full wheelchair access, just to give an example.
Isabel?
Yeah, I agree. I think more of the problems are going to be in the very rural and island situations that we wouldn't want to see premises, that access to children who are living on a remote island somewhere isn't going to be stopped because of regulation. I think Stuart said everything else, really.
Yeah, I think you list things quite well. Multiple entries, disabled access, modern play facilities, waiting spaces. It's almost like that's a wish list, but the reality is that sometimes that will fall short of that, but still does the job adequately. And to get up to that standard, you're looking at quite a huge resource implication. So if that was the case, it would need to be addressed in the financial memorandum. Is that more or less what we're
That's
saying?
right. If the standards were set significantly higher than what our current physical premises are across the country, then yeah, of course that would require investment. There's also the added issue, as I mentioned, is that we don't own all of these premises. We may be renting space in these premises at the weekend, for example, and it wouldn't be in our gift to start knocking down walls and putting in various different changes to the physical environment, because they're not our buildings.
Yeah. Okay, thank you. Liam Kerr.
Thank you, Convener. Good morning. You might have heard me ask earlier on about the enforcement of court orders in Section 16 of the Bill. In relation to breaches of court orders, you and others have suggested a range of interventions that would help resolve the issues families are experiencing. So you suggest mediation, family therapy and the like. Do you take a view on whether these should appear on the face of the bill? And how can courts or service providers such as yourselves ensure that these interventions are only used in suitable cases? Specifically, we've had some representations that they may not be appropriate where there's domestic abuse, for example.
Well, as far as intervention such as mediation is concerned, we are fully aware that mediation is not always in the strict sense, in the best interests of the parties involved. And sometimes we get court referrals where there has been domestic abuse, and we have had to say, actually, we always see people individually first. That's the first thing. And if they're not comfortable with mediation, then we just write to the court and say, we don't feel this is appropriate for mediation. There's more and more mediation being done by what we call shuttle mediation, where the two people aren't in the same room. Now, there is a bit of debate that goes on all the time within Relationship Scotland, for example, whether or not the outcomes of shuttle mediation are as good as or as positive as face-to-face mediation, but it is possible to do. It is more expensive because you would need 2 mediators for shuttle mediation. Sorry, I don't know if I've explained, but basically the parties don't meet. You have them in the same building. Again, you know, you would have them arriving and leaving at different times. They never meet. And the mediators, one mediator goes between the parties and mediate. So that is a possibility.
That's part of it. I could also add that, as I mentioned before, the investment we had from the big lottery helped us employ and develop a range of family support workers across the country, and they've been very successful in helping families where it's already been determined that this is safe contact to go ahead, but to help families move towards contact where there might be issues, say, just around the fallout from the breakup between a couple. As you'll know, many people, when they break up, there may not be domestic abuse issues, there may be a whole range of other issues that lead to very, very strong feelings against one another. And our family support workers have been proven to be very successful working with families in those situations to help break down some of the concerns about contact, and they've been able to help facilitate good positive contact in a whole range of cases that wouldn't otherwise have taken place. As others have said clearly, we would never support punitive measures against resident parents. It's trying to work out the reasons and understand the reasons for why contact's not taking place, and to try to work through those issues with the families themselves. Thank you.
Just for the avoidance of doubt, is the understanding that there would not be, mediation wouldn't be appropriate where there is domestic abuse?
I think in many cases, again, there's a judgment to be made now. Again, this is a range of debate about this now. Some would say that it should be absolutely automatic, that no one should be allowed to go through mediation. Or there may be some cases where the person who's been subject to domestic abuse may wish to and can be supported through mediation, but in the majority of cases, mediation wouldn't be deemed appropriate where there's domestic abuse.
And supplementary finally from John.
On that very specific point, and there's very strong views on this subject, as you know, what would you use to establish that there was no coercive control and behaviour being exerted on the person who agrees to undertake in these circumstances? Because that's the very nature of that.
Yeah, it's a very key part. It's part of the relation of the training that we provide to our family mediators. All of our family mediators go through extensive training where domestic abuse is a key part of this. We have asked Scottish Women's Aid to look at the training we provide to our family mediators to see whether it appropriately covers the whole issue of domestic abuse, and they've confirmed to us that in their view it does. And that is, you know, the families we're working with, these issues are absolutely central to them. Now, some of what Isabel was alluding to there is in terms of even ways mediation can take place, like shuttle mediation, for example, where the people don't even meet each other. There's a range of different mechanisms that we can use at times in cases where people wish to go ahead with mediation. But we do understand it's a very sensitive and a very difficult area, and in the majority of cases, mediation would not be viewed appropriate where there's been cases of domestic abuse.
Thank you.
That concludes our questioning. Thank you very much for what's been a very helpful session, and we look forward to receiving the additional information that you've indicated you'll provide the committee with. So thank you for that. Just before we move into private session, can I have agreement for the committee to take item 4, which is our approach to the defamation bill, and item 5, which is our work programme in private? Thank you for that. We now move into private session. That concludes part of today's meeting. Our next meeting will be the public part of today's meeting. Next meeting will be Tuesday, 21st of January, when we will continue with our evidence-taking session on the Children's Scotland Bill. And we now move into private session. Allow the public gallery to clear.